What should legal and compliance teams prioritize?
So legal and compliance teams should focus on two priorities. One, mapping exposure, and two, reviewing documentation. So on mapping exposure, I would identify which products fall within the expanded definition of product, particularly software, AI systems, interconnected digital services, and digital manufacturing files. Map the full supply chain to identify all potential economic operators who might face liability. So that's component manufacturers again, that's importers, authorized representatives, fulfillment service providers, and online platforms. Now on documentation and traceability, the disclosure obligations under Article 9 of the new Product Liability Directive mean that documentation practices become directly relevant to litigation outcomes in particular. And so insufficient or poor documentation does not merely create evidential gaps, but failure to disclose relevant evidence triggers a presumption of defectiveness. So it is especially important to ensure that documentation is organized and as it should be. So I would review compliance with mandatory safety requirements under union and national laws, because non-compliance again can create a presumption of defect under the new PLD.
From that perspective, what the risk and governance teams should focus on?
Risk and governance teams should, number one, stress test disclosure readiness, and number two, reassess insurance assumptions. So one, on disclosure readiness, the directive requires that evidence be disclosed in an easily accessible and easily understandable manner. So the court, if the court deems it appropriate, the court can order that it be produced in a way that is easily accessible or easily understandable. This means that companies need systems capable of locating, of organizing, and presenting technical evidence in litigation, and probably in a quick manner, because usually you receive it, if you are ordered to disclose evidence, oftentimes court will give you a very short time period to do so. So there's extra pressure on companies to ensure that they can be ready. Courts are empowered to take measures to preserve confidentiality of trade secrets, but the default expectation is disclosure of relevant evidence. Now, looking at insurance, the extended exposure of the 25-year latent injury rule, that leads to broader categories of, that and in conjunction with the fact that there are broader categories of liable persons, presumptions favoring claimants as well, that all may affect product liability insurance pricing, availability of product liability insurance, and even the terms of product liability insurance. So the Commission's future evaluations will explicitly examine the availability of product liability insurance for companies.